Hello and welcome to you civic son of a bitch. My name is James Day, part-time journalist, full-time silly duffer. Love, death and taxes, the big three inevitable aspects of life. You can explain the first two under the simple fact that we are just humans, born to copulate, extend the species and then eventually bugger off across the River Styx. But the last aspect, taxes, they're a bit different because we invented them. Unfortunately, there is good reason for taxes, and the reason is tied up in this little idea we like to call the social contract. Now, unless you were born on a flagless raft in international waters with no parents to claim you, the country in which you came out of your mother's loins actually matters a fair bit. In effect, babies, upon entry into the world, sign a kind of social contract. At the age of about 9 months and 30 seconds, your parents have made the decision to sign you up to a society of their choosing.
Society.
Now, this could mean you're part of a roll call of the population, otherwise known as a census, or be asked to vote someone to represent your community in the government. You may even get drafted to fight a war, which is always fun, but you'll almost definitely be asked to pay taxes. Why? Because taxes pay to keep the government running. So taxes are basically every citizen's contribution to the government, because who else is going to fund it? Now, what do governments do? Well, they build things, destroy things, write laws, repeal laws, fight wars, make peace, have leaders who take in Engadine Maccas. You get the idea. However, there's one catch. They're meant to do these things in the public's interest, because why else would we be paying them? There's many other ways for individuals to contribute to society, but tax is one of those core ideas that help us explain this idea of the social contract. We, the people, come together and contribute to a government so it can make decisions on behalf of our society.
Society.
But where did this wacky idea come from? I mean, while there's always been a relationship between an individual and society, the concept of a social contract itself didn't really come into play until the period known as the Enlightenment. It's the deep state.
As I was saying, the Enlightenment was a period when a bunch of Euro trash and treasures got all excited about reason, science, human progress, individuality, and keeping the church out of government affairs. You had Dennis, Diderot, Voltaire, Isaac Newton, Immanuel Kant, and this cute little shit-stirrer, Jean Jacques Rousseau. In the mid-1700s Europe, he got famous after winning an essay competition held by the Academy of Dijon. They asked entrants to write an answer to the question, which in essence asked, as we get smarter in the sciences and arts, do we also become better people? While everyone was tweaking in optimism for the future of humanity, Jean Jacques gained infamy for writing this: no. In fact, he didn't just say no, he argued our progress had actually taken us backwards, morally speaking. Rousseau believed that with the development of civilizations, humans create more things that they want, but don't actually need. He had this idea that the quote-unquote natural man who gets his protein from an egg was being squeezed out of society by the quote-unquote artificial man who has to buy 5 kilos of whey to start his day. In writing, Rousseau discussed this belief that Native Americans or rural Swiss were no less decent or happy than the most civilized Europeans. He even went further to say that they actually showed higher moral standards and were much more cheery. Anyways, for Rousseau's 1754 hit, Discourse on the Origin and Basis of Inequality Among Men, he attempted a thought experiment. What's a thought experiment? I never thought you'd ask.
Deep state, taking my job, telling my jokes. Anyway, what were we talking about? Oh yeah, thought experiment. Well, a thought experiment is basically an imaginary scenario that is meant to test an argument or theory, like Schrodinger's cat or the trolley problem. Anyway, Rousseau basically sat down and thought about what a human being is at its most basic, without all the bells and whistles of civilization around them. He came to the conclusion that natural man is most comfortable either in small groups or at home alone. Rousseau proposed that when there's few others around, issues like envy, greed, and all that nasty business, it doesn't come up as much. But then, why do we have a society? Well, Jean Jacques made a guess that some major crisis forced human beings to create societies. While this solved some of humanity's woes, Rousseau believed it created an even bigger man-made problem called inequality. Essentially, we all come into this world equal, but society requires ownership over what people do and own, which is what causes conflict and injustice. So we've got a problem. But what do we do about it?
Well, one of these ideas was to create a new kind of education, based on lived experience and the development of individual character. Rousseau's other idea was moral education. First, he believed young people should learn about the consequences of their actions. But his most notable solution for humanity to recover its natural goodness was through this idea, which is at the heart of our discussion today, called the social contract.
Now, I'd love to get into the nitty-gritty of this concept by talking to some of the enlightened thinkers who helped push it along. But apparently, they're dead. However, thanks to the miracle of artificial intelligence, that's not an issue anymore. If you want to go further down the philosophical rabbit holes with me, check out my interviews with AI, Jean Jacques Rousseau, Thomas Hobbes, John Locke, and my favourite from ancient Athens, Socrates. But for those lacking an attention span, don't worry. We're going to put Subway Surfer on just to help you get through it. In the meantime, I'm going to ask you to stick around here first because we've got some examples of the social contract in the modern world to get to. Do you believe in the government? Do you have faith in its inalienable ability to tell you right from wrong, even when you are the wrong? We often talk about the government like it's a faith system, because it kind of is. Together we agree to its laws, elections and processes as an agreed upon way of managing our society. We believe in that social contract. But what happens if you don't believe in the government? Over the last few years, you've probably heard more about sovereign citizens. These are individuals who have essentially chosen to abandon or reject the social contract of the country they live in. In other words, they believe the government's laws, elections and processes do not apply to them. I had a few interactions with sovereign citizens during my time in the nation's capital, when a number of their members became involved, among other fringe groups, in what became known as the 2022 Canberra Convoy, an exotic offshoot of Canada's own Freedom Convoy. It's easy to make fun of these individuals and their interesting ideas, but many of them suffered a lot, personally and financially, during the COVID-19 pandemic. And in their confusion, they tried to figure out what was going on. Some of these people unfortunately fell into these conspiratorial rabbit holes, including the sovereign citizen movement, which is another fine export from the US of A. Now, the movement in Australia is largely based on a misunderstanding of the law. While messaging varies, the Rule of Law Education Centre says the movement at large shares a few beliefs. These include disputing the sovereignty of the Australian government, claiming laws only apply if individuals consent to them, like a contract, that the Magna Carta invalidates the Australian Constitution, and refusing to respond to a name and calling themselves a flesh and blood man, which somehow means they're not subject to legal authority. These are incorrect for a few reasons. First, under federal law, sovereignty, meaning the authority of the government, rests in the people. We're running the joint. And if we allow multiple sovereigns within one system, there's going to be disagreements about whose laws we follow, and it'll just get too complicated. Second, everyone physically in Australia is bound by its laws. Regardless of whether you know about, agree or disagree with the law, there is no way to excuse yourselves from the legal system. Third, while the Magna Carta, 1215 CE, played a huge role in forming common law, which we adopted from the English Empire, it does not have any authority over Australian laws. Fourth, I'm going to let you work that one out for yourselves. Now, sovereign citizens have been here for a while, but they've generally been considered by authorities to be harmless. Meet Leonard Castley, a farmer from WA who, back in 1970, founded the legally unrecognised independent state of the Hutt River Province. Prince Leonard's 75 square kilometre property took on this responsibility after he had a tiff with the state government over wheat production quotas. After the media caught on to his newly founded, legally unrecognised independent state, the Hutt River Province became a tourist attraction, replete with postage stamps, a currency, 10,000 non-resident citizens, and a treaty with Indigenous landowners. Unfortunately, in 2017, the Prince of the West and his son, Arthur, got caught doing a sneaky one on the tax office. Together, they were ordered to pay off a $3 million tax bill. When they appeared in court to refute the order, WA Supreme Court Justice Ren Lemure said the royal family's arguments were bizarre, irrelevant, and gobbledygook. Now, this all sounds like fun and games, but due to the rising number of sovereign citizens, Australia's court systems are being pushed to their limits. Last year, the Federal and Family Court told Ariel Bogle, an investigative reporter from The Guardian, that while it did not collect data on the frequency of sovereign citizen involvement, anecdotal evidence points to an increase in recent years, especially following the COVID pandemic, and increased access to online resources. Ms Bogle heard from several family court and independent children's lawyers that fringe legal movements like sovereign citizens were online discussing the claim that children were property. Now, this can make legal matters around divorce and child custody quite tricky. Using these arguments, which have no legal basis, not only slows down the trial and uses up already strained court resources, it can also lead to kidnappings. Ms Bogle found several examples in recent years where a parent involved in a custody battle was convinced of these pseudo-legal arguments and had run away with their children. This is an example of the more extreme elements in the movement, which have been showing up more and more since the COVID-19 pandemic. In 2023, the Australian Federal Police told the public it was looking at sovereign citizen groups that they considered violent in nature. Then Acting Assistant Commissioner of Counterterrorism and Special Investigations, Stephen Demeto, said in a presentation on the movement that what we've learnt is whilst these groups present and behave very differently to other extremist groups, there is an underlying capacity to inspire violence. We are largely seeing these groups take action in the form of non-violent protest, including co-opting other demonstrations. However, there is also a propensity for fixation on high office holders and public figures, as well as some within the movement urging violence. Part of the AFP's fear was spurred on by the events of January 6 in the US. Another was from the Weambler attack in December 2022. This event saw Gareth Train, his wife Stacey and brother Nathan in an armed confrontation with Queensland police on their rural property, where, over several hours, they ended up killing 2 constables, a neighbour, and themselves. While the trio had ties to the sovereign citizen movement, this event has come to be dubbed Australia's first fundamentalist Christian terrorist attack. Why? Well, it's part of the reason why targeting these kinds of extremists are so difficult for security agencies. They believe in a lot of different ideas, but usually don't have any established links to organised terror groups. This makes them hard to identify and prevent from being a risk to the public, as they're more likely to go out and commit their own solo acts of violence. The Australian Security Intelligence Organisation claims the pandemic accelerated the radicalisation of various conspiracy theorists, including members of the sovereign citizen movement. Academics have said this is generally due to a dangerous cocktail of too much social media, severe isolation, underlying issues with mental health, and an anger towards the authorities. It's an unfortunate truth that in our society today, it's so easy to be radicalised. Put under the right pressures and given some decent Wi-Fi, you can whip up anybody into a storm of fiery resistance to the powers that be. Sometimes the reasons are justified, but sometimes they're based on bullshit. What's important is that you're able to use your brain and work out fact from fiction through reliable sources. Easier said than done. But to start, it helps to understand that faith in the government is very important, because if you don't believe in the system that governs your society, why would you respect its laws? Why would you respect its institutions? Why would you accept its social contract? Okay, we've seen what can happen when people choose not to recognise a state, but what happens when a state doesn't recognise you? Now, you heard me say earlier that the British brought to Australia this thing called common law. This is the idea that laws develop over time through the decisions made by judges on each kind of court case. One of the main ideas that stuck with the British through this legal system
is that land is property. Coming from a society that's largely developed over the centuries through various kingdoms fighting each other over farmland, the British got to Australia with a certain mindset on how things should be managed, especially when it came to land. But this mindset was quite different from the Indigenous peoples already here. While Indigenous groups didn't have Christianity or laws all written out in English, they did have established beliefs and customs that varied across the continent. Despite this, none of the British were interested in trying to recognise or understand these long-held traditions. Instead, the Empire, upon settling in Australia in 1788, automatically imposed its own legal system on the continent's Indigenous peoples. Now, as subjects of the British Crown, Indigenous groups should have received equal treatment under English law with all the legal protections it provides. In fact, King George III told Arthur Phillip, the first governor of the New South Wales penal colony, that when he arrived in Australia with the First Fleet, they should endeavour by every possible means to open an intercourse with the natives and to conciliate their affections, and if any of our subjects shall wantonly destroy them or give them unnecessary interruption, it is our will and pleasure that you do cause such offenders to be brought into punishment. In reality, the Empire wasn't too interested in negotiating its plans for continental domination. To realise their plans, the colonisers made the assumption Indigenous groups didn't have any agricultural practices to assert their control over the land, a government to negotiate with, or a large populace that were ready to challenge their conquest. Murder was also considered a rightful action by the British convicts when defending their so-called land rights. So a lot of the time when Indigenous people got in the way, they were killed. There were hundreds of massacres that took place throughout all of Australia from 1780 all the way into the 20th century. Many of these, but not all, have been mapped by a research team up at the University of Newcastle, a project that was started up by historian Professor Lyndall Ryan, which she managed until her death last year. I once had the pleasure of interviewing Professor Ryan for a story I was writing about an alleged massacre of Ngunnawal people that took place beside Lake George, which is about a half hour north of the nation's capital. She told me that mass killings weren't technically legal under British colonial law in Australia, but since the law was so often poorly applied to Indigenous peoples, there was little chance of finding justice for the victims. While colonial governments largely used their police forces to split up Indigenous groups, disperse them to avoid further conflict with European settlers or throw them into jail, Professor Ryan said they could also be culprits in such massacres. In the Waterloo Creek massacre, which took place just outside Moree in regional New South Wales, a mounted police detachment from Sydney is believed to have killed between 40 to 300 Gamilaroi people in defence of British interests. For the alleged incident next to Lake George, Professor Ryan suspected it could have been a mounted police brigade unit from Goulburn who had come upon a group of Ngunnawal people on their way to Queanbeyan. Local elders had passed down the story that after being killed, their people's bodies were thrown into the water. However, Professor Ryan said it was more likely that their remains had been burnt and hidden to erase any evidence of the incident. She said that the telling of these stories would often be altered by Indigenous groups in order to cope with the fact that their people had not undergone the appropriate burial rites that would grant them access to the spirit world. These crimes rarely, if ever, found any kind of justice in the colonial system. However, there was one famous case of the Myall Creek Massacre, which eventually led to some kind of legal recognition for Indigenous peoples. In 1838, a dozen British settlers murdered around 28 unarmed Wurriyai people in northern New South Wales. 11 settlers were initially arrested, but found not guilty by a jury. Then New South Wales Attorney General John Hubert Plunkett and his junior counsel, Roger Terry, were responsible for prosecuting the case. Unfortunately, their only eyewitness to the events was a servant at the Myall Creek station, an Indigenous man named Davey. I say unfortunate because at this time, the law did not allow Indigenous witnesses to provide sworn testimony. The British believed Indigenous Australians could not uphold an oath to tell the truth, as their own spirituality meant that they had no fear of God or understanding of divine judgment for sin. So while they could be put on trial as defendants, they were not allowed to testify on their own behalf, present evidence from other Indigenous individuals, or bring to court their own cases of aggression toward them. Mr. Plunkett didn't take kindly to this idea as a devout Catholic. He believed all peoples were equal in the eyes of God and deserved equal access to the law for protection. After the first trial failed to bring about a conviction, the Attorney General and his aide managed to secure a retrial on a new charge for 7 of the original 11 settlers. And thanks to the evidence of an Indigenous child's rib bone that was found in the ashes of the burnt bodies, the pair managed to find all 7 individuals guilty of their crimes before a judge sentenced them to death at the end of a rope. Following the trial, Mr. Plunkett continued to advocate for the legal recognition of Indigenous peoples. On 3 occasions, he attempted to pass a bill that will allow Indigenous people to present evidence in court, which eventually came to effect about 7 years after his death in 1876. This was a small win in a long history of injustice against the Indigenous peoples of Australia. It wasn't until 1967 that they were recognised as human beings, and it took until 1992 for the courts to overturn the idea of terra nullius, correcting the falsehood that they weren't even here at the time of British colonisation. Yet to this day, Aboriginal and Torres Strait Islander peoples are not mentioned in the Constitution. Australia had a crack at changing that about 2 years ago in the 2023 voice referendum, but the people said no.
The social contract is just one of many theories or ways to find some structure and meaning in the relationship between an individual and society. It has evolved as a concept through the works of many writers who made their own contributions to it while trying to find reasons in the conflicts and crises of their own times. But don't expect to find the absolute truth in it. Just appreciate it for what it is. One of many ideas, not the only one. This reminds me of an anecdote I once heard about the famous anthropologist Dr. Margaret Mead. She was once at a university giving a lecture, and a student asked her, Dr. Mead, what was the first sign of civilization? And Dr. Mead took a moment and responded, a healed femur. When humans first got out of the trees and started living in caves, someone breaking their leg was a death sentence. Even if they survived injuring the largest bone in the human body, that person could no longer move well enough to gather food, fight off predators or infections that would likely follow them until they died. So how did they get better? Someone had to help them. Someone had to gather food, bring water, find shelter, and steer away the predators. Someone had to sacrifice their own self-interest to heal another individual over many, many months.
Thanks. Nice story, isn't it? Makes you feel cuddly inside, gives you hope for the future of humanity. Well, turns out it's complete bullshit. But hey, that's why we cite our sources here at You Civic Son of a Bitch.
Coming from a I had a few interactions with sovereign Now, sovereign citizen. Okay. Yeah. Yes. Seek cars. Your own time. Oh, that was very nearly a. I am just a sweaty boy. Ah, it's the deep state.